is Roxana from Eutopian Lettings, and welcome back to another tutorial about property management. In this video, I want to show you a few things that you can use, a few tools that you can use to learn about deposit deductions and how to get your deposit back, either as a landlord or as a tenant. There are 3 deposit protection schemes, and when a landlord collects a deposit from a tenant, he needs to deposit the money in one of the deposit protection schemes within 30 days. And then the landlord needs to send the certificate of deposit to the tenant. So now, assuming that you are at the end of a tenancy, either as a landlord or as a tenant, I want to show you a few things that you might want to learn about deposit disputes. Maybe you are not even at the end of a tenancy, maybe you're in the middle of it, or maybe you're just looking to start a new one. The most important thing is to have a very good check-in inventory, because the checkout, if it's not done properly, you can still go back and do it within a week. But if you don't have a check-in inventory thoroughly done at the beginning of the tenancy, then you can't really claim anything back, because as a landlord you have to prove that you had something good and now it's damaged. Of course, there are instances when the law is on the side of the landlord and not of the tenant, but the main thing you have to be aware of is that the person who has to prove that damages happened and they suffered and they have to pay for things is the landlord. One of the deposit protection schemes has created this really cool interactive way of learning how this deposit protection resolution center figures out who they award the deposit to. So I want to show you now a few case studies that you can play with. So this is like a game online, but it's really well done, and it's actually based on real case studies, and this will help you figure out how to build your evidence as a landlord or how to get out of paying a deposit as a tenant. Okay, so let's just try one of them. So if you click on this one, for example, here. So basically in this you're gonna get to be the adjudicator, and then you're gonna be told at the end if you have made the right decision or not. So basically you're gonna go through the whole process and you're gonna understand how they judge whether the tenant keeps the deposit or the landlord. Okay, so let's start here. The first one says instructions. Click on the tab. Okay, this is you can read that by yourself. So the claim: when you apply for deposit deduction as a landlord, after you've seen the checkout report, you're gonna have to make a few claims. So basically you can make, I don't know, as many as you like, but this is one of them, and the deposit protection scheme will look at each one of them individually, because you might not have evidence for one, but you might have evidence for another one. So in this particular claim, this is just a little one, it says the landlord wants to claim $749 for cleaning and redecoration. Okay, the dispute. The tenant said they had told the agent the checkout inspection date was not convenient. And then you have the tenant statement saying, we booked the contractor to come and to do some cleaning and remove our stuff. The agent booked the checkout midday. Even though we said it was too early, contractors would not finish. So I told them we would need until 3 p.m., but they changed the time to 2 p.m. The lady who came to do the checkout was surprised we were still there, but the agent knew we wouldn't be finished until late. Okay, the landlord statement. The tenant told me the cleaner would be finished by 1 p.m., so I booked a checkout clerk for 2 p.m. The house was filthy, but the clerk completed the checkout. I went back later after the cleaner had finished, but the place was still filthy. I took photos and I sent them to the tenant. Okay, and this is what they each say, but now they have to bring evidence to prove that their statement is true. The checkout report shows the cleaner was still working in the property. So they do have an evidence that there was a cleaner there. The landlord's photographs. So there are photographs as proof, but these photographs have a date of after 1 month after the tenant moved out. Of course, in 1 month anything can happen. There might be lots of viewings done in that place. Okay, and now that you've seen both evidence and both statements, you have to make a decision. Okay, so if you click on the landlord, it says, no, this is incorrect. And if you click on the tenant, in this particular case, it says that it's correct. And sometimes you might get it right, sometimes you might get it wrong. But what is important is that you can click on this button and you can figure out how they thought about things. Okay, so in this instance, it says the checkout report was of virtual no evidential value. Both the landlord and the tenant agreed work was done to the property after the checkout was completed. So the report wasn't a true record of the condition of the property when the tenant vacated. The landlord's claim would have been successful if they had taken photographs sooner. As the photographs were taken a month after the tenant left, they held less evidential weight. Given that a month had passed before the photographs were taken, a number of people would have entered the property and dust would have been accumulated. So that's how they thought about this case. Yeah, so this is really fun. We can try another one if you like. Let's just see how do we go back. So I'm going to close this one and we can try another one. And after that, I will put the link to this in the description. If you're based in the UK, you can use this either if you're a tenant or a landlord. You will kind of have a clue about how to prove that you have done something or how to prove that you haven't done something. So as a tenant, for example, if you claim that something was there initially or something was broken initially, you have to look at the inventory before. So if the landlord has an evidence that the area was clean and the things that you said that you didn't break were clearly stated and shown in the picture that were brand new and they looked well, then the landlord has an evidence. But if there is no evidence of the things being new or being in the shape that the landlord claims, then the landlord would not have the right to claim anything from the deposit. Okay, so here is the second case study. The landlord is claiming £280 for costs awarded by the court in section 21 possession and 724 legal fees paid to their solicitor. The court told the tenant to pay £280 in court costs, which they accepted, but they disputed the claim for 720 in solicitor's fee. The tenant statement: I will pay 280 as the court order said I had to pay it, but why do I have to pay their solicitor's fee as well? They chose to have a solicitor in court, I didn't. There was no need to have a solicitor as it was all quite straightforward. And the landlord statement: the tenancy agreement said that the tenant had to pay my reasonable costs for professional advisor in enforcing the remedying a breach of the tenant's obligations. I had to get a court order for possession so that the tenant should pay my solicitor's costs. Evidence: tenants agreement, clause included as described by the landlord, invoice for solicitor fee 720, copy of the possession order with the court order instructions, the court order instructing the tenant to pay £280. Okay, my guess in this instance is that the landlord, interesting, so it's incorrect. Let's see, is the tenant? Wow, yeah, so the tenant is correct. So in this instance, the tenant is correct. Anyway, the idea is that, and you can, oh yeah, let's find out why. So how was this decision reached? The court order was made under the Section 21 accelerated possession procedures. The landlord was awarded 280 in court costs, which the tenant agreed to pay. The landlord employed a solicitor to conduct the court proceedings for him, relying on a clause that said the tenant should pay their professional advisor's costs. The tenant is only liable for solicitor's fee if they breach their tenancy obligations. Section 21 is also known as the no-fault procedure, where no reason needs to be given when recovering a property. All the landlord needs to show the court is that the tenant has been given notice and due process has been followed. Therefore, as the tenant hadn't breached their contractual obligations, the clause didn't apply and only the court costs were awarded to the landlord. Right, and let's have a look at another one. Let's see, breaking up the band. Let's see this one. So I will put the link. You can check these out yourself. It's much more fun when you click the buttons and you interact with it and you read by yourself. I also enjoy watching YouTube videos to learn about everything. But yeah, today I'm going to be the teacher, not the learner. Okay, so here's the claim. One tenant was living a joint tenancy of 4 people. The landlord claims 1,299 to reprotect the deposit for the 3 tenants still living at the property. Ooh. He needs to pay that much for deposit. That's like their whole deposit. There's no way he can claim that. That's ridiculous. The tenant said the landlord hadn't given a sufficient reason as to why they were claiming money that should be paid to the tenants. Okay, the tenant statement. The landlord hasn't given me any information about this. I don't know why they're claiming the deposit if it belongs to me and the other tenants. The landlord statement. The tenants staying on at the property had agreed that their deposit shares would be carried over to the new tenancy. Okay, well, if he has evidence, he might be able to get that. But he's not going to keep the deposit. He's just going to re-protect the deposit. Key evidence. No evidence was provided. Well, if none of them has evidence, he can't keep anything. Let's see, tenants, correct. Obviously, so in most cases, if the landlord wants to do any deductions, as I mentioned in the beginning of the video, he needs a lot of evidence. He needs the emails exchanged between the tenants and the landlord or the text messages. He needs the agreement to state which clause they're breaking and so on. Otherwise, it's really hard for a landlord to deduct anything. Okay, let's see what they say here. Why was this decision reached? The adjudicator can only make awards to compensate the landlord or the letting agent for losses incurred as a result of a breach of obligations by the tenant. The landlord's claim did not show that the tenant had breached their contract. The adjudicator had no choice but to return the deposit to the tenant. For the deposit to be reprotected, the landlord would need to give the deposit back to all 4 tenants. The remaining tenants would then each pay a share of the deposit into a new tenancy. That makes sense. Okay, so yeah, that's it. I will leave the link so you can play a bit more with this website. It's really nice. So it's designed by one of the deposit protection schemes. It's called depositprotection.com. I was reading about it. So this is something that every tenant or landlord should know about if they live in the UK and they have a deposit. Okay, so I hope you enjoyed this video. If you want to learn more about property management, I have a 5-day property management course that will teach you a few things about how to manage a property. Please subscribe to this channel if you want to see more videos like this. And feel free to ask me any questions and send me any suggestions about future videos that you would like me to make about properties in the UK and lettings and property law. And have a great day, and thank you so much for sticking until the end of the video. Bye for now.